Good morning. Today I'll be running through the key implications of the abolition of the default retirement age. The points that I'm going to focus on in today's session are the key changes, the transitional regulations with key dates and tips on what to do now, pointers on approaching the decision over whether to remove compulsory retirement or seek to justify it, next steps for those removing compulsory retirement, and finally some tips on seeking to justify compulsory retirement for those retaining it. On the 13th of January, the government confirmed that it would be removing the default retirement age of 65. There has been a lot of public debate regarding the pros and cons of this step, from concerns of increased costs of older workers and the potential for performance deterioration, to the advantages of retaining experience and reducing employee turnover. As a perhaps rather unlikely candidate, being McDonald's, has even come out as heralding a diversely aged workforce as a way of replicating the family unit. Perhaps the jury is out on that one. As a result, compulsory retirement will have to be justified or will constitute age discrimination. As an exception, it will not be discriminatory to refuse to offer insurance-based benefits to over 65s due to the increased premiums which would be incurred. Over 65s will be eligible to bring unfair dismissal claims, and the right to request procedure that we have come to know and accept, if not love, is to be repealed. To bridge the gap between now and October, the government issued some transitional regulations. The latest draft, which was issued on the 1st of March, sets the parameters of the process to follow, and I've distilled some key dates as shown on the slide. 5th of August 2011, this is the last date for employers to give notice of an intention to retire, provided that the employee is 65 or will be 65 by the 30th of September 2011. There is a little time left. 5th of January 2012. This is the last date for employees to exercise the right to request to work past retirement, and that date applies where 12 months' notice of intention to retire is given on the 5th of April 2011, and the employee waits until the last possible moment to request to work past retirement. 3rd of October 2012. This is the last date for compulsory default age retirement, where notice is given on the 5th of April. The right to request is exercised on the 5th of January, and a maximum of 6 months extension is agreed. As if a longer extension is agreed, a fresh notification will be required, and we won't be able to issue those after the 5th of April. So, what to do now? Diarise your key dates. Consider retiring any employees who are aged 65 or who will be 65 by the 30th of September 2011, and issue any intention to retire notifications by the 5th of April 2011 at the latest. Please note the recent case law highlights that there is a requirement to consider requests in good faith. The decision is to be appealed, but for now we are stuck with it, and so we must be taking care to ensure that the decision is not presented as predetermined. Whilst there is no obligation to give reasons for refusing a request to work past retirement, it may actually reduce the likelihood of claims to do so in some cases. When deciding whether to remove compulsory retirement or to seek to justify it, you should consider that, to justify compulsory retirement, you must be able to show that the practice is a proportionate means of achieving a legitimate aim. Our view is that it is likely to be difficult for most employers to justify a blanket compulsory retirement age. It may be hard to show that the legitimate aim could not be met by a less invasive step or by an older retirement age, so if going for 67, why not 68? In addition, arguments that age uniformly results in performance deterioration are unlikely to be well received by judges who are often in that age bracket themselves. Unfortunately, we are expecting a surge of claims, and that these claims are likely to be of significant value. The high press attention is likely to stimulate claims, and employees may try to take advantage of employers trying to adjust to the change in law. There may be an increase in the value of claims generally, particularly for career loss claims, as previously the loss was capped at around age 65. Next steps for removing compulsory retirement. We would advise that you vary any references to automatic retirement at 65 in contracts or handbooks. Whilst there is a potential saving of notice monies arising from such clauses, employees could claim automatic dismissal on reaching 65 without the employer having taken any other step, and claim unfair dismissal and age discrimination. It is likely to be particularly difficult to defend such claims if you've decided not to retain compulsory retirement on the basis that you did not think you could justify the practice. Revisit your appraisals and include questions on future plans. The safest approach, as advocated by ACAS, would be to have this discussion with all employees regardless of age, and we should be making sure that the questions asked are open and do not presuppose a particular response. Currently, many skilled employees retire and work as consultants, often for their former employers. There is nothing to stop this continuing after voluntary retirement. Whilst there is no specific obligation to do so, considering flexible working options such as changes to hours, job sharing, changes in roles or responsibility may provide a solution by retaining experience and potentially saving cost by allowing employees to alter the way that they work. It's a good time to review your ill health and performance management policies to ensure that they are robust and practical, and in the case of ill health entitlements, to ensure that they are not overly generous. But the key is in applying these proactively to employees of all ages. This may involve a bit of a culture shift, as many organisations have to date not perhaps managed their employees reaching retirement age as proactively as other employees. We should also be ensuring that managers are fully trained on appraisals, performance management, ill health, and avoiding age discrimination generally. For the brave, those seeking to justify compulsory retirement, check that your reason for requiring retirement is a legitimate aim. The following may be deemed to be legitimate: promoting recruitment and retention by ensuring defined career paths, collegiality, so allowing people to retire with dignity, facilitating long-term employment planning, and the extra cost of employing older workers, although this final one should be used in conjunction with another aim, as the current case law highlights that cost alone is unlikely to be sufficient to be a legitimate aim. Assess the retirement age and whether to have different ages for different roles. It may be particularly difficult to justify a blanket retirement age for roles which differ significantly. Set your paper trail, the lawyer's mantra. Carry out a detailed assessment supported by research and recorded in writing, including why retirement is necessary, the legitimate aim, why that age or those ages are necessary. Ideally, perhaps these should be over 65. As we touched on earlier, this may be difficult to satisfy this step, as it can always be asked, why not a year older? Given that the government decided that 65 was no longer appropriate for default retirement, it may be best to go for an older age. But what will be important is linking the age to the legitimate aim. It will be very important to show the alternatives which have been considered and why they have been rejected, as this goes directly to proportionality. Organisations should be prepared to apply the retirement age consistently amongst the roles that it has been set for, as it may be difficult to justify if exceptions are made, for example perhaps for senior management in the case of a blanket retirement age. A fair process must be followed. Unfortunately, the government has not issued any guidance on this, but for now it may be wise to opt for a 6-month notification procedure to allow employees to plan for retirement. That brings me to the end of my session. Many thanks for your time.